Callaghan, for the past 20 years, this House and this state has been trying to rectify the terrible damage that was done to women, children and babies who were placed in or who were born in institutions that operated on this island in the 20th century. I regret to say, notwithstanding the efforts of this House and previous governments, we haven't succeeded in rectifying the terrible damage that was done to those people. I think we need to go back and look at 1999 because it was an important year in the start of a process as our attempted rectification of the damage. Mary Rafferty, the late journalist, produced an outstanding programme in 1999 called States of Fear. I think she produced it and it was broadcast in April and May of that year. Shortly afterwards, the then Taoiseach, Bertie Ahern, made an historic statement. He apologised on behalf of the state to children in institutions who'd been abused over the years. Since that time, we as legislators tried to introduce legislation to rectify some of the damage. In the year 2000, we introduced and enacted the Commission to Inquire into Child Abuse Act. It resulted in the Ryan report being produced subsequently. Then we had the enactment of the Commission of Investigation Act 2004, which wasn't for any specific issues related to the abuse of children and women, but it was a mechanism by which the state enabled inquiries to take place. And within the rubrics of that piece of legislation, we had inquiries into the Diocese of Dublin, which was published in 2009, and we had inquiries into the Diocese of Cloyne, which was published in 2011. We've also seen since then that we've started the process of having an inquiry into mother and baby homes in this island. I also recall in the previous Dáil that we discussed here legislation in respect of adoption information and tracing. All of these pieces of legislation have three issues that are absolutely core to their discussion and to their development. And the first of them is a public issue, but the second and the third are private issues that are more important. The public issue that is of importance is that it is to the benefit of this state that we find out and inquire into what happened in these institutions throughout the 20th century. It is our obligation as a country to ensure that we do proper historical research and that the government formulates an inquiry into it so that we can have an official record of what was a very dark time in our country's history. And we have sought to achieve that objective. The second objective, however, we have not yet achieved, and that is the objective to provide a remedy to individuals who were incarcerated in these institutions or who were born in these institutions or who were adopted out of these institutions. Now, I spoke to a man yesterday who's a constituent who phoned me, and he's a survivor of Golden Bridge and St. Joseph's Navan Road. And he understands he was illegally adopted via the Rotunda Girls' Aid Society in St. Patrick's Guild. That man has been trying for 40 years to identify who his parents were and what is his identity in terms of the place from which he came. And my belief is that that man has an entitlement to find out about his identity. The third individuals whose privacy and whose life needs to be recognised and respected are the very unfortunate women who were placed in these institutions and who gave up children in terrible circumstances and who, in giving up their children, wanted to protect their confidentiality and their anonymity. So there are three groups and three issues here that I think need to be given careful consideration when we are appraising any legislation. My own view, and this is a view I communicated to Minister Zappone when we were discussing the adoption legislation, my own view is that nothing really trumps the right of an individual to find out about their own identity and their own background. And I don't think any right of confidentiality trumps that right of an individual to find out about their own identity and their own background. In fairness to Minister O'Gorman, he recognises that as well. And I know that he is going to bring forward legislation that is going to provide some certainty to people so that they can access information about their provenance. It has gone on for too long. There has been too much legislative inactivity and uncertainty and legal ambiguity about whether or not these people can be given the very simple information that they seek to obtain. And I would urge Minister Gorman to ensure that the next piece of legislation, the crucial piece of legislation that comes out of his office, is legislation that gives that vulnerable group of people the right to find out about their identity. That, I believe, is a fundamental right that trumps all other rights we're discussing here. Now, the legislation which has been brought before the House today has received considerable appraisal, controversy and recognition. But I think we need to look at how the Mother and Baby Inquiry was established and the legislation under which it was established. As I said earlier on, we introduced in 2004 the Commissions of Investigation Act. It was enacted by both houses of the Oireachtas. And under it, it provides that once a commission delivers its final report, it's dissolved. And if a commission is dissolved, it's the same as a company that's dissolved. It can't operate. It can't be sued. It can't take any steps. It is dead, and nobody can act on its behalf. So I can understand why there was a concern on the part of the Minister. I also think we need to recognise that before the dissolution of a commission, there's an obligation on the chairperson to deposit with the specified minister all evidence received by and all documents created by or for the commission. Had the minister not introduced this piece of legislation, that's what would have occurred. But Section 43 doesn't just operate on its own. You have to also look to see what is contained within the other relevant provisions contained within the 2004 Act. And in particular, there's the provision in Section 41 which suggests and states that records of the Commission, including documents that are lodged with the Minister under Section 43, 1 and 2, that they will be within the meaning of the National Archives Act. They are records that come within that. And on the expiry of 30 years after the date of the Commission's dissolution, they will deem to have been available. So that's contained within Section 41 of the 2004 piece of legislation. Now, no matter what the Minister does, he can't get around the fact that in Section 39 of the 2004 legislation, which was amended in 2018 by the Data Protection Act, there is a provision in terms of the Data Protection Act and the restriction on it. And that section now reads that Article 15, which is the right of access of the GDPR, is restricted to the extent necessary and proportionate to safeguard the effective operation of commissions and the future cooperation of witnesses insofar as it relates to personal data provided to a commission for as long as the data is in the custody of the minister who may have it under Section 43. Now, my reading of that is that it provides a mechanism for people to apply to get their records, and if it doesn't conflict with the provision set out that I've just read, well, that they will be successful in their application for access. However, if I'm wrong about that, the Minister, and I listened to his speech earlier on today, he gave a commitment. He said that he is going to bring forward this legislation to ensure that people will have access to information that relates to them. Those people don't need legislation from the Minister if it is the case that their personal information is retained and they have an entitlement to access it. In that case, they can seek it. But lest there be any doubt, the Minister has committed that he will bring forward extra legislation to deal with the matter. If you look at the bill that we're dealing with today and we're discussing here this evening, can I just say, in parentheses, I think it would have been more appropriate if we had more time to deal with this. I know the Minister says that we're operating under a deadline because of the impending publication of the report. I don't think there's any difficulty in delaying the extension of a report. Nearly every inquiry that's ever been set up in this country has sought an extension of time in order to produce its final report. It may be unusual for a government to play that card the other way, but I do think we could have asked the Commission to hold off on the delivery of its report until such time as this legislation got fuller consideration. But under this piece of legislation that we're discussing, and I've looked through it with a boring eye, and I don't see anything in it that says that the records have to be sealed for 30 years in this legislation. But I can understand the concern that people have because of the 2004 legislation, and that's where the problem arises. So I think, Minister, it's incumbent upon you, and you've said it previously, to ensure that you bring forward legislation that once and for all provides people who are adopted, people who are in mother and baby homes and were adopted from them, that provides them with an avenue to get information and certainty about their identity. Our state owes those people that. Thank you.